Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning and welcome to our Spring Forward Legal Updates monthly webinar series. Today is the third of our 2021 monthly webinars, and today we're discussing the top 4 tips for your top 4 legal docs. Joining me today is Jessyca Greenwood. Both of us are, and I'm Lisa Stam. We're both lawyers at SpringLaw. If you're one of our clients, you know already that we are employment and contracts lawyers at our virtual law firm, although everyone's virtual these days, based out of Ontario. Welcome to those who are new to our webinars and to our client and HR community. First, a little bit of housekeeping. Today is an AMA style session, so please feel free to ask any questions along the way. We're happy to make this as conversational as possible. We are going to just, walk through the 4 main legal documents that we think every workplace needs, but for sure ask questions along the way in the chat function of the software. You can download the slides, the slide deck itself in the handouts tab. And then finally, for any more information about our law firm, just come to our website at springlaw.ca, where we have a bunch of resources like our award-winning weekly blog posts that you can subscribe to, our publication for COVID-19 for employers that we have really kept very, very much up to date for over a year now. I can't believe it's been over a year, but it's been a very popular resource for employers looking to understand what is the latest roller coaster of changes they have to keep up with in the world of COVID. Feel free to join our monthly newsletter. You can find more information on the 444 toolkit that we've put out for this month, and then more information about our subscription program for employers. Okay. Let's jump in. Our roadmap for today is, is to talk about our 4 documents. So we're going to ensure your employment contracts are enforceable, talk about termination clauses and that ensure that exits can happen calmly and reflect company culture. We'll talk about the must-have versus the nice-to-have workplace policies. We know Rome wasn't built in a day, and not every employer has a great big HR department or division that can take care of this. So we want to help, especially small employers, just cherry pick what you have to have today, and then talk about releases and how that influences clean breaks and post-employment restrictions, and then overall how to reduce legal risk on all of this.
So looking at how to assess if your employment contracts are enforceable, this is a big one. The law has changed in this area in 2020, which we've had a number of blogs about and spoken to our clients about over the last year. Looking at your employment contracts, you want to make sure that your employees, your workforce, is in the right category. Are they truly employees who are working for the business at the direction of their management, or are they independent contractors who set their own hours and bill the company accordingly? Depending on what type of workforce you have, that will determine what kind of contract you need. Flipping over to our next slide, really important in an employment contract to set out termination provisions. When a relationship with an employee starts, that's always the best time to ensure that your contract is enforceable, and that's the time when the relationship is at its best and you can have discussions with them about what's in the contract if needed. But really important to make sure that the employee signs the contract before they actually start working for the company. That way we will be able to make sure that the contract is enforceable, and we want to make sure that contracts have the minimum standards that all employees are entitled to based on the Employment Standards Act. And that's things like pay if you're going to terminate them without notice, sick leaves, vacation pay, benefits, things like that. We want to make sure that all of that is in there. And then there's some other key pieces of an employment contract that you may want to consider, like having a provision for temporary layoffs, if that becomes something that your workforce needs during COVID, a remote worker policy, and having schedules that include the employee's key responsibilities.
Yeah, and if I can just comment, especially for anyone who's listening in who is from an American workplace, in Canada, every employment relationship is deemed to be based on a contract, whether express or implied. So whether you have an actual contract in place or not, there is always an underlying contractual relationship. So employers can either have the courts dictate what those terms are going to be in the course of litigation, where all ties just go to the employee, and employees are deemed to be the vulnerable parties, so that they're really, it's where you live in this employee-friendly jurisdiction. Or employers can be proactive and really craft the terms of that contract from the beginning. And so, having, I think we probably say this in every single webinar, having enforceable contracts and policies in place are the key risk mitigation for employers. But part of the why of that is this underlying employment relationship that always exists, which is different than in most states in the US, where you have that at-will relationship and the employer can just fire at will. It's just not the way it is here. So taking the lead on that as an employer up front can really help mitigate your risks as you move along.
That's a really good point. And just to follow up on that, if you're using an employment contract or a template that's pre-summer of 2020, there's a good chance that the termination provision that is contained in that template is no longer valid. So if you are using that or continuing or planning to use that, you really should have a lawyer take a look at it to make sure that it's valid if you want to be able to limit what the company will have to pay if you terminate the employee.
Mm-hmm.
So looking at other parts of the employment contract that may be important to your workforce is whether or not you need to think about any non-competition or non-solicitation clauses. And what does that mean? What other terms do you need in the contract to protect the work product of your company and other restrictive covenants? So we want to make sure that those types of restrictive conditions that you will place on an employee are reasonable, and the courts have a whole set of conditions and tests that they look at to make sure that they're reasonable. So that's something that you'll want to consider depending on the needs for your business and ensure that's in the employment contracts.
Mm-hmm. And it's another area where especially non-competes are deemed to be unreasonable unless the employer can prove otherwise. So there's really a heavy onus on employers to prove that the non-compete is necessary. So it's always an uphill battle to enforce them. We have a question that came in, and I don't understand the question, so I just want to read it out so that whoever sent it in can clarify for me so that we can answer it. For HR consultants who provide service to multiple clients, can these documents be used multiple times given copyright law? And I just want to clarify, are you referring to the documents in our 444 toolkit, or these, or just in general employment law contracts? If whoever wrote that in, and I only see the question, not who wrote it in, unfortunately. So if you can just pop in a clarification to make sure that we're answering the right question for you.
Absolutely. And so we do want to make sure that your employment contracts are enforceable, and that's our number one tip. Make sure that you have the right kind of contract and template for the employment relationship that you have and the kind of workforce that you have. And then let's make sure that that all of the conditions in there are enforceable.
And then for type of contracts, did you want to talk through the different types of contracts? Because I think, there's always the big picture employee versus independent contractor. And when you're dealing with an independent contractor, it is more of almost like a B2B type of relationship. But when you're looking at fixed term employees, I know you've run across this in a file recently as well, that it can be a really tricky type of relationship to have.
Absolutely. So one of the things to think about is whether or not, if you're thinking about a fixed term contract, it's good to get some advice about whether or not that's the best policy. And it's based on what goals you're looking to achieve. Is it that you're unsure about the employee and how they will perform within your business? Would you rather have a longer probationary period as opposed to a fixed term contract? There are these different types of options for the employment relationship, but generally speaking, the issue with a fixed term contract is that if you don't have a valid termination clause, the employer can be on the hook to pay the employee for the entire term of the contract if you decide to terminate that contract. So really important in the fixed term situation to have a valid termination clause, or just make that fixed term period a shorter period.
Okay.
And so our next top tip, which we've said a little bit about already, is to ensure that the employee signs the contract before they actually start working for the business. And this can be a bit tricky, because when you're onboarding an employee, you bring them into the fold, you might have them come to meetings or meet the team, but it's really important, and the case law says in order for a contract to be valid, the employee really does have to sign it before they start working for the company. The second point in there is consideration. Let's say that you decide to update your contracts. After our webinar today, you heard our message, the case law's changed, you want a valid termination provision, and you're going to roll out a new set of contracts to your current employees. So we're not talking about new employees, but the ones you currently have. You would provide those employees with consideration in order to sign a new contract, especially if you're changing your entitlements. The case law also talks about the importance of consideration. That's the employee receiving something in exchange for them signing off on an employment contract. Now, employers ask, what happens if the employee won't sign? There are provisions that you could provide the employee with working notice that you're going to change the contract, but consideration is essentially money or something of value in exchange for the employee signing off.
We advise on this issue a lot. It's a tricky one, and especially right now with workplace, everything just always in flux because of COVID. Everyone's really having to modify and change up and address just changing conditions all the time. So this is the issue of consideration. It's a really old legal concept, but it keeps popping up over and over in all the contracts right now.
And our last top tip in this area is to look at the probationary period that you have for new employees. The Employment Standards Act sets out a probationary period of 3 months. However, your employment contract with an employee could set out a longer probationary period as long as the parties agree to that longer probationary period. And then if you decide to terminate that employee during the probation, if it's past the 3-month mark, you have to ensure that you give the employee any entitlements that they would have under the Employment Standards Act for that post 3-month period.
Practically months 4 and on in a probation period are a little bit useless, because you still have all the same statutory obligations. It's just that it can give you that longer runway from a performance management type of view, but you would have that anyways. So I like it when people just stick to 3 months if they're going to have a probation period.
And tip number 4 is the termination provisions. Really, really important that we ensure that termination for cause and termination without cause is very clear in the contract itself. One of the other one of the other aspects that we look at introducing in an employment contract is having the idea of a release already built into the termination provision. So if the company decides to terminate the employee and will pay them for doing it, terminating them without cause, that the employee will receive a little bit more if they sign a release. So in exchange for releasing the company from any liability, they get paid a bit more money. And having that in there can be helpful to just introduce the employee to that idea right from the beginning, that this is just part of the company's culture and process. And we want to make sure now, in light of the changes to the case law that occurred in 2020, that you do have that essential wording in your termination clause that ensures that the whole termination provisions are enforceable. The case that came out last summer called Wakesdale says that if your termination for cause provision is invalid, your whole termination section is invalid. And that has caused a lot of discussion and a lot of grief in employment law over the course of the last year.
Mm-hmm.
Templates are our number 5 tip, which is have a up-to-date enforceable template that you can use. Consider rolling that out with your existing workforce and have that in place for new employees. It's a great way to be cost effective. You can customize it as you need for your business, but you can also make sure that you continue to update it if the law changes.
So the question earlier about templates, it was in reference to our 444 toolkit, and I'll talk a little bit about that at the end. So we'll talk about that then, and I'll answer that question. But we got another question. What about if an employee's original contract stated they will go from full-time to part-time at a specific date? When drawing up the contract detailing this change to part-time, is consideration necessary? So if you're modifying, the theory is if you're introducing an adverse term, if it's something negative to that employee, so certainly if you're reducing pay or reducing vacation or eliminating benefits, those are all adverse terms where you're going to have to give something in exchange for them to enter into that new contract. If the parties have all agreed when you first start that, look, for the first year it's going to be full-time and then you're going to move over to part-time for, after that, that's an unusual circumstance, but if that's the case and the parties have agreed on that up front, then you don't need to introduce new consideration because it's all part of that moment when the deal was struck. But if you want to change the deal and introduce an adverse term or something less for the employee, that's when you need to introduce some consideration. Okay, let's zip this along. Our second topic here is only second, and I know we're 20 minutes into our program here, writing termination clauses that reflect company culture and calm exits. So in addition to all of the technicalities about whether something is legally enforceable, I think it's always important to also talk about the why of terminations and the how you implement it, because that's more often than not, we represent both employees and employers, and what we hear from employees is often not that they care they got terminated, although often they do, but it's how they were terminated, that they're so hurt and upset and angry, and now they want a bigger remedy because of that. So we live in a world where there is employee turnover, and it's not just millennials. We can't always just blame millennials, who, by the way, are now in their 40s and running companies. So it's everybody. It is the norm that there is high turnover. Few are going to stay at a place for 30 years. So bake that into the overall structure. Assume people will leave, have cross training, have all that stuff that you would normally have, but have good conversations up front about terminations. And then when it comes to the moment of termination, plan like crazy for it ahead of time. The almost always where the battles are is when there's a rash decision that a supervisor or a manager is super ticked at someone and they just fire randomly without the planning, and that's when it becomes a problem. So planning like crazy for that termination meeting. And even if you suspect that your termination provision is now not enforceable because it's 10 years old, there's still so many things you can do to just have the parties have an elegant exit that settles it out without having to turn it into a great big expensive legal battle. So really preparing the documents ahead of time, thinking through what is a reasonable package to give to the person. What does it reflect? What was intended in the contract, technical legality or not? Is it relatively consistent with other packages that you would give in the organization, so that you're not seen to be targeting this person for some reason? And then when you get to the actual termination meeting, think through things like timing. Don't fire at the end of the day on a Friday, not before a long weekend. Give people time to go and deal with the business questions that they're going to have. Go see an advisor, go to the bank, go do things that will help them address the immediate worry of being fired. The meeting itself, yes, in the world of COVID, you can do it by video. It's more than a year ago, we would have had a little bit more of an ambiguous answer to that. It doesn't feel great, but it is what it is. We're in COVID, but you still need to do all the other regular things. Making sure that you've got a bit of a script ahead of time so that you understand what you're going to be saying, you know what kind of passwords you want from the person. Just do everything you can in that meeting. Always have a witness, and then really deliberately plan out what your closing line is so that you can click the end meeting button it will be awkward. It will just be awkward, but having a sense of how you're going to wrap it up will be useful. And that way that termination meeting is what sits in everybody's mind. So it's and nobody likes it either side of the table, but it's a pretty important piece of all of it.
Just two things to add there really quickly is that I've found employees tend to be very hurt when they're fired over Zoom, and it's a very short and curt meeting. If your business is restructuring and you have to let employees go and it's just a matter of the finances that have come up during COVID, try to think of some nice gift or token that you can give them for their service instead of just you're terminated and Zoom meeting now. That seems to really ignite people's emotions. And also one other consideration is many employees haven't been back in the office. They may still have their belongings in the physical space. What arrangements could you make for them to ensure that they get their belongings back?
Mm-hmm. Someone just asked whether that Zoom termination meeting should be recorded. I mean, if it was a regular in-person meeting, would you ever record that? And how would the other person feel? I'm not a proponent of recording things. Certainly you can get the consent and it's all okay, but everybody feels a bit on edge when it's being recorded. I definitely think every employer should have there should be at least two people from the company and have one person take careful notes. But I'm writing, but they should take careful notes. Probably by typing, and I don't know that you need to record if you anticipate it's going to be a really problematic termination, maybe, but I don't know. It just adds a lot of. They can see if it's being recorded, right? You can't, I guess you feel like you have to be sneaky about it. Where are we here? The last issue on this topic, writing termination clauses that reflect culture, is thinking through the length of notice. And this is not the moment to be overly miserly, because people are really scared in the world of COVID, and companies are, I know, equally very scared. But that little bit of a gesture, a modest bit of generosity can go a long way to saving the company money in the end, because it'll settle faster. So, I would be what's the saying? Pound foolish, penny wise. But do it anyways. Think big picture is what I'm trying to say on that one, and think about the big picture monetary and reputational outcome. Do you give reasons for the termination? I love telling employees not to be overly, or employers to not to expect that the employee will never be satisfied about the why, that there will, that you can never actually satisfy. Was there a bit of a glitch there? Did everybody, I think it popped off and on for a second there. Did Jess, did that glitch on and
You're
off?
okay. You're back now.
Yeah, okay. Like everybody else, I've got 4,000 Wi-Fi access in my house right now because of online schooling, so you just never know. Giving reasons in the meeting. I know employees want to know why, but they will never, ever, ever be satisfied why. Nobody wants to get fired. So I would always advise against engaging any long debate about the why, because there's no win on that one. But stating some basic reason is a way to address that human nature need to know why. And if it's business restructuring, it's business restructuring. Just state that. If it's performance issues, getting into all the why of it is going to be probably not a great use of time in that termination meeting. There can be time for questions after. Okay, must have versus nice to have policies. And I know we're heading up on our time, so this will probably be more of a list than anything else.
Absolutely. So I'm going to zip through the workplace policies. The law requires that employers have these key workplace violence and harassment policies and occupational health and safety policies. There's also accessibility policy requirements. And if you employ over 100 employees, you have to have a pay equity plan. These are the absolute musts, and there are various nuances here. You may want to have an employee handbook with all of your company's policies in there. But we do want to make sure that there is some formality, and that should there ever be a complaint, your workplace can say that you do have all of these policies put in place, that your employees know about them, they're posted somewhere, or they've received a copy. Those are all really important. So for nice to haves, we have a few suggestions. If you have employees working from home, you may want to think about a work from home or remote worker policy. Also good to consider an accommodation policy, especially dealing with issues that your employees may face, like mental health, stress, medical issues, things like that. You want to be able to give the employees the benefit of the doubt and have some policy to be able to accommodate that. Remember that it's always the employer's duty to accommodate up to undue hardship. If you have any questions about that, we're always happy to advise on those issues. And it's one of the areas where you should seek some legal advice to ensure that you are accommodating up to that point that would be legally considered undue hardship, and try to avoid a human rights complaint. Performance management policies are important because you don't want your employees to feel like they are being individually singled out if you have to try to give feedback on performance issues. So good to have some policies in place about what the company will do if your employees are not meeting their objectives. And last, what do you do if your employees can't attend work? What is the process that the employee is to follow to make sure that they report if they're going to be absent from work, if there's sick issues or childcare issues? How is the company dealing with that and accommodating that? And that has been complicated in the world of COVID because there's all different kinds of leaves. There's different reasons people may need to be off. So good to have some thought and process around this.
I know we're heading just up until 11. We've got a little bit more to go. If you scheduled and you've got something to do at 11, for sure, hop off. We will be distributing the recording of this video after, and it'll be on our YouTube channel. So if you need to hop off, that's totally fine. We don't take it personally. We know people have busy work lives. Okay, the last topic though, releases, the clean breaks, post-employment restrictions, and reducing legal risks. The release is probably one of the most legalese of documents that you would have of the core documents that you need to have in any workplace, whether you have one employee or 1,000 employees, if you're going to exit someone, you really want to have that release that provides the closure to the matter. So once the parties have settled on what the settlement terms will be, the release is the legal document, and it really is. There's no way to get around that. We try very hard to put everything in as plain English as possible, but the release is the legal document that is the shield for both parties, but particularly employers, to show that there can be no more claims, no more court cases, no more human rights claims, no more anything related to the workplace. So having it really carefully written is a key piece to preventing further litigation, and to really just have that nice clean break. Some of the ways where a release is not enforced is if there wasn't consideration in exchange for it. So we've already talked about consideration, but if you pay someone only ESA upon termination, they're already legally entitled to that. So they're not getting something more in exchange for signing off on the right to sue for more. So you can only actually get a release if you give more than the basic Employment Standards Act minimums. Even a bit extra will allow you to get that release. If the employee didn't have capacity, whether it's a mental health issue or it would have to be a pretty severe. It's not just a mental health issue, but like a full capacity issue. If it wasn't actually settled, you're not going to get them to sign off anyways. If there was any sort of misrepresentation or a mistake, or if there was duress. So if you fire somebody, and in that moment, especially if it was an in-person meeting, slide the documents across the table and say, here, it's an awesome deal, sign off here. You just never do that. Always give them time to take it home, think about it, talk about it with their spouse or a friend, and then come back and sign off on it. Otherwise, the employer is really seen as exerting duress to force the issue.
So I'll just speed through. I can speed through the takeaways so that we get everyone back to their day, but just really consider having some key core documents. And so regardless of whether you're a small organization, a not-for-profit, or a big business, all organizations need to focus on having valid employment contracts, making sure that they have policies in place and a solid release should you need to get an employee to sign off. That can help limit your exposure and also work to the company's advantage to promote a transparent company culture.
Mm-hmm.
So with that in mind, we can move over to telling you a little bit about the 444. We've told you all about the why you should have these documents, but the 444 is the how. And I think, Lisa, you created this amazing resource for our employers and our HR professionals so they would have the tools in their toolkit. But it's called the 444 because you turned 44 and SpringLaw just turned 4. Am I right?
No. I did recently have a very big birthday, but it was not 44, I can tell you that. We just want to do a quick shameless plug at the very tail end of this, just to we put together this 444 package, which has the 4 key documents people need, the 4 workplace guides, and 4 helpful checklists. It's our 4-year anniversary of the firm, and we've been incredibly grateful to our clients and our HR community that has really been amazing over this last year, really worked together, and we've really had this really great community just come along with us, and out of gratitude we wanted to put together this toolkit. It's 4 of your 4 main documents in these different areas. It's normally valued at $2,800 plus tax, but we're selling it right now for the month of April for $444 to stay on theme. So there's our website link if you want to pop over to that again, we've been grateful to our community and just really wanted to help people get this reset right now with the case law that's changing so quickly and all the COVID laws that keep changing, the lockdown, the not the lockdown, the lockdown again, and to have this chance to just get your docs up to date at what I think is a very affordable amount and have a bit of a reset as we move forward. I hope we're done our lockdowns, that this third wave is the last of the waves, and we can, get businesses open again over the summer. It's been a very long haul for so many of our clients. So hopefully this allows us to spring forward into normalcy at some point.
Well, thanks so much for joining us today. We hope that this was helpful, and please join us again on May 19th at 10:30 for our next webinar. Details and registration will be available on the website. If you have any questions about today or what we talked about, or you're interested in the 444, please follow up with us. Our emails are on this slide, or visit our website.